This case concerns what the law calls a restrictive covenant. The restrictive covenant in this case binds the owner of an area of land near Maidenhead not to build on that land, which I shall refer to as the application land. The restrictive covenant is enforceable by the owner of the neighbouring land. What happened here was that the owner of the application land, a property developer, deliberately broke that restrictive covenant by building houses on the application land. There is a legal procedure provided for by a provision in an Act of Parliament, namely Section 84 of the Law of Property Act 1925, by which a person bound by a restrictive covenant can come to a legal tribunal to seek to have the restrictive covenant discharged or modified on certain specified grounds. So after building the houses, the property developer made an application under Section 84 before the relevant tribunal to have the restrictive covenant modified. The neighbouring landowner objected to that application. Now, all this may sound somewhat dry and legalistic, but there is real human interest in this case, and it raises a fundamental dilemma. This is because, on the one hand, the houses that have been built are 13 units of much needed affordable housing, and the application under Section 84 seeks to ensure that they do not go to waste. On the other hand, on the neighbouring land is a new hospice for terminally ill children, and the owner of that land, the Alexander Devine Children's Cancer Trust, which I shall refer to as the Trust, seeks to uphold the restrictive covenant to which it's entitled, so that the terminally ill children in the hospice can fully enjoy in privacy the use of the grounds without being overlooked or otherwise detrimentally affected by the new houses. The tribunal found in favour of the property developer. It decided that the restrictive covenant should be modified to allow the occupation and use of the application land for the 13 affordable housing units on condition that the property developer paid the trust £150,000 in compensation. That decision was overturned by the Court of Appeal, which held in favour of the trust that the restrictive covenant should not be modified. Housing Solutions Ltd, which has acquired the application land from the property developer, now appeals against that decision to the Supreme Court. The Supreme Court unanimously dismisses Housing Solutions Ltd's appeal and refuses the application. The judgment is given by myself, with whom Lord Kerr, Lord Lloyd-Jones, Lord Kitchen and Lord Hamblin agree. This is the first time that the highest court has been required to decide an appeal on Section 84. And in order to decide this appeal, it's been necessary for the Supreme Court to undertake a careful analysis of how the different subsections of Section 84 fit together. The original version of Section 84 laid down 4 grounds under which the tribunal was given the jurisdiction, that is the power, to discharge or modify restrictive covenants. But following a report of the Law Commission in 1969, the law was updated by the addition of a wide 5th ground, where, to simplify slightly, the restriction is impeding the reasonable use of land, and that impeding of reasonable use is contrary to the public interest. So we can refer to this as the contrary to the public interest ground. The central legal issue in this case is at what stage is it relevant to consider, and what should the impact be of the property developer's cynical breach of the restrictive covenant by going ahead with the construction of the buildings, knowing full well that this that this was in breach of the rights of the trust. The reasoning of the Supreme Court in this respect, departing from the reasoning of the Court of Appeal, is that the correct interpretation of Section 84 is that the developer's cynical conduct does not fall within any of the 5 jurisdictional grounds. In particular, it does not fall within the contrary to the public interest ground, because on the correct interpretation, that ground has to be narrowly construed. And the tribunal was therefore correct that that contrary to the public interest ground was established by the property developer on these facts, despite the property developer's cynical breach. Nevertheless, the cynical breach should have been properly taken into account when the tribunal went on to exercise its discretion. And for particular reasons set out in the judgment, the Supreme Court concludes that the tribunal did not properly take that cynical conduct into account in the exercise of its discretion, and that had it properly been taken into account, the Section 84 application would and should have been refused. The effect of our decision is that the restrictive covenant stays in place in its original form, and the trust will be entitled to seek the standard legal remedies for breach of covenant of an injunction and/or damages. In particular, our decision does not mean that the 13 housing units must now be taken down. If the trust chooses to go to court to seek an injunction ordering the taking down of the houses, what happens to the houses will be a matter for the court which hears that claim to decide, applying established legal principles. But it may be, for example, that the trust will prefer to reach a financial settlement of this dispute, and it's only realistic to recognise that the impact of the Supreme Court's decision today is to strengthen the trust's hands in relation to any such financial settlement.